Hello and welcome. My name is Paul Smith. I'm a solicitor and risk management consultant at Travellers, working with our lawyer insureds to help them deliver a safe legal service. This is the first podcast in our series of 10-minute briefings. These are short presentations on the risks we see in legal practice based on our claims experience here at Travellers, experience that goes back almost 20 years and covers the range of solicitors' businesses, from sole practitioners to global law firms. We'll start by defining risk. Risk is tricky stuff to pin down, and that's partly because we use the same word to describe different things. Sometimes it's something bad to be avoided, as opposed to something good, an opportunity, something to seize. It can be a catch-all word, seeing risk as having both good and bad aspects, attempting something that may have downsides if it fails, but there are also upsides if it comes off. And it can be a general term for uncertainty. Given the number of ways the word gets used, it's perhaps not surprising that there are lots of different ways of defining risk. But it's uncertainty that underlies many definitions, including this one from the International Standards Organization, the ISO, in its Risk Management Standard 31000. Risk is the impact of uncertainty on objectives. In this talk, we'll be focusing on the risks that could affect a key objective of any legal service provider, the ability to deliver a safe legal service because of so-called operational risk. So what makes up a risk? Any risk has three elements: a cause or causes, which alone or together can generate an effect, or an error or event, which can lead in turn to one or more consequences. What does this model mean for solicitors acting for a client? Let's start with causes or sources of risk, causes or sources of uncertainty. These fall into four groups: people, product, process, and risk maturity. Some of these terms are self-explanatory, some perhaps less so. So we'll explore them further. Starting with people. Delivering a legal service involves a range of people who come with a mix of issues to address. For example, clients. Who are they and why have they instructed you? What are their objectives and expectations? What are their assumptions about the work they want done, especially around complexity, time, cost? Employees and outsourced suppliers. Those delivering the service. Are they clear about what is expected of them? What is their capacity, their capability? What levels of support do they need to do their job? Then those running the business, directors, members or partners. What are their expectations around service delivery, the hours people should work and billing targets set against resourcing? Is there a mismatch? How do they support those on the front line? In particular, is there a culture which encourages people to raise challenging issues? Product. This is about managing the delivery of your service to meet your client's objectives. So the way you organize your work when you are, for example, resolving proceedings, negotiating a commercial deal, drafting documents, or concluding a property transaction. Next, process. This covers the firm's infrastructure, which supports people when they are delivering the product. This can include training and knowledge management programs, IT systems, case management and diary systems, due diligence processes such as AML or KYC, organization of the teams and workloads, and arrangements to supervise and assist those on the front line. The questions here, some of the uncertainties: are these systems robust? Do they facilitate the work, make it easier? Do they need extra informal steps to work? Are they seen as something to work around? Finally, risk maturity. This is a measure of how embedded risk management is within an organization. A risk mature venture has a culture of raising and maintaining risk awareness across the business, a risk framework for managing risk, made up of risk architecture, strategy and protocols, and an ethos of discipline, defined by the American writer Atul Gawande as operating prudent procedures and working together. Low risk maturity or risk immaturity, a lack of awareness and or capability of the need to manage risk, is itself a cause or source of risk. So a range of causes with potential to generate uncertainty, leading to errors, events, or effects. These also fall into four groups based on our error codes: advice, dishonesty, drafting, and retainer management. Advice. A range of examples from our codings here: failure to spot and deal with conflict issues or cost liabilities, advising correctly but on the wrong facts, getting the law or procedure wrong, or a faulty analysis of the prospects or quantum. Dishonesty. This can take many forms. In recent years, it's been aided by technology. The dishonest client, for example, engaging in identity theft, often helped by providing instructions remotely or using fake ID. An attack on client account, either by someone within the firm, say by fraudulent accounting, or by someone outside, for example through social engineering in cases of Friday afternoon or whale fraud. Investment, where funds invested by the firm or handed to third parties to invest are stolen. Mortgage fraud in property transactions, and third parties, often criminals who have used ransomware to extort money, or by spoofing emails, breaking into email chains, passing themselves off as a party to a matter, and diverting funds to accounts they control. Drafting. We have one drafting error code, but it covers a range of drafting errors. Typos, reversal of numbers or people, clauses omitted or included in error, or apparently complete documents, but the clauses are ineffective or produce the wrong result. Sometimes the negative impact of technology, using the wrong precedent on the system, emails sent to the wrong person, copying in an error, sent without sight of the file. Retainer management. We have a number of errors which go to management of the retainer. Clear instructions not followed, missed specific or general time limits, and inappropriate action. A broad term, it covers slips and trips in the course of delivering the service, either in the process of delivering the retainer or in the systems which support delivery. If the causes or sources generate an event or error or an effect, there can be consequences. Here are the four main ones. For clients, lost opportunity in litigation, defective documentation which fails to secure rights or impose obligations, deals compromised due to errors of judgment or slips in process, properties purchased for more than they are worth because of unexpected adverse interests. These can generate claims for damages, and along with civil claims, there may be breaches of regulation, so references to the SRA, SDT, or OIC. And all of this can affect a firm's reputation. Bringing it all together, a map for solicitors' operational risk. Causes grouped on the left: people, product, process, and risk maturity, which alone or in combination can trigger errors in the central column: advice, dishonesty, drafting, and retainer management, which can in turn lead to consequences: adverse impacts on clients who respond with claims for damages, which may in turn lead to regulatory action. And all of this could affect a firm's reputation. So a series of links generated by uncertainty. Risk management aims to disrupt those relationships, those links, by reducing uncertainty. This means identifying the cause-effect-consequence relationships and assessing the risks in them, and adding appropriate controls to manage those risks. And we'll be looking at how to do this in later podcasts. For more information on risk management guidance, in particular the other podcasts in this series, please go to the address on the screen. A final point, our disclaimer. Please take a moment to review this. As a précis, this talk is for guidance only, and there's no liability over the information supplied, which is also not exhaustive. So a précis of the précis, terms and conditions apply. I hope you found this presentation helpful. Thank you for watching.